I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series discussing SEC disclosure requirements, and in particular the 341-page Regulation SK concept release and request for public comment issued by the SEC on April 15, 2016. Today I am continuing a review of the various specific topics discussed in the Regulation SK concept release. Item 101 of Regulation SK requires a description of the company's business, and Item 102 requires a description of the company's materially important physical properties. These items provide the necessary foundation needed by investors to make investing and voting decisions. This basic information also assists in putting other disclosure items into context. Currently, Item 101 requires a description of the general development of the company's business over the past 3 years for smaller reporting companies and 5 years for other classes of company, or such shorter period of time as the company has actually been in business. Item 102 requires disclosure of the location and general character of plants, mines, and other materially important physical properties. Examples of information required include disclosure of the basic background of the business, such as the year of formation, type of entity, any bankruptcy or receivership, any material reclassification, merger or consolidation, the acquisition or disposition of any material assets outside of the ordinary course of business, and material changes to the business operations. In addition, Item 101 requires a narrative description of a company's business, including 13 specific areas. For example, the principal products produced and services rendered, new products or segments, sources and availability of raw materials, intellectual property, the seasonality of a business, working capital practices, dependence on certain customers, and the number of employees. Emerging growth companies must satisfy all of the standard requirements. However, smaller reporting companies benefit from several scaled disclosures from the standard requirements, including, for example, an elimination of the requirement to discuss seasonality, working capital practices, backlog, or government contracts. As with other areas of discussion, the SEC has requested comment on whether the current disparities between the requirements related to smaller reporting companies and emerging growth companies should be eliminated. Many of the detailed requirements included in Items 101 and 102 may not be relevant in today's business environment. For instance, many businesses no longer have physical locations, but rather run through virtual offices. Likewise, businesses in today's world often outsource or hire independent contractors, and as such, the number of employees may not add value to the disclosure. The SEC also discusses eliminating redundancies in the 101 and 102 disclosure requirements. For example, there are several categories in Form 8K that request the same information elicited in Items 101 and 102, as does the MD&A and footnotes to financial statements included in all 10Ks and 10Qs. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.